Follow and subscribe Stenolab India for correct pronunciation, accurate speed and clear voice. Legal dictation. Exercise number 14. Speed 100 words per minute. Get ready for the dictation. Start. In the matter before the court, the plaintiff, herein referred to as Alpha Technologies Incorporated, alleges a material breach of contract against the defendant, Beta Solutions, LLC, arising from a commercial agreement, executed on or about 1st July 2023. The plaintiff contends that the defendant failed to fulfill its contractual obligations under the terms of the binding agreement, specifically relating to the timely delivery and installation of proprietary software systems. Pursuant to Section 3.1 of the contract, the defendant was obligated to deliver a fully functional software suite no later than 30th September 2023. The plaintiff asserts that the defendant's failure to deliver, by the stipulated date, constitutes a breach of the express terms of the contract, thereby entitling the plaintiff to seek remedies, available under both the agreement and applicable law. The defendant, by and through its counsel, has filed an answer and affirmative defenses, asserting that the delay was occasioned by force majeure circumstances, including unforeseen and uncontrollable supply chain disruptions. Furthermore, the defendant contends that any delay was immaterial, and that substantial performance was achieved within a reasonable time. However, the plaintiff argues that no force majeure clause is applicable under the contract, and, even if it were, the circumstances alleged do not rise to the level of an excusable delay under established case law. The plaintiff seeks damages, both compensatory and consequential, for the losses suffered as a direct and proximate result of the breach. Additionally, the plaintiff is requesting specific performance, compelling the defendant to complete all outstanding obligations under the contract, or, alternatively, rescission of the agreement and restitution for monies paid. Discovery is ongoing, and both parties have served interrogatories, requests for admission, and requests for production of documents. The defendant has filed a motion to compel responses to certain interrogatories, asserting that the plaintiff's objections are without merit and not made in good faith. In response, the plaintiff has filed a protective order, seeking to limit the scope of discovery to matters directly relevant to the breach. A pretrial conference has been scheduled for 15th May 2025, at which time the court will address pending motions, set deadlines for dispositive motions, and determine the admissibility of expert witness testimony under Daubert standards. Should the matter proceed to trial, it will be a bench trial, as both parties waived their right to a jury trial in the initial agreement. The case raises important questions regarding the interpretation of contract provisions, the enforceability of limitation clauses, and the standards for determining commercial reasonableness in performance. Ultimately, the court must assess whether the defendant's conduct constituted a breach of duty under the contract, and whether the plaintiff is entitled to equitable relief or monetary compensation. In conclusion, This matter underscores the critical importance of clear contractual drafting, comprehensive risk allocation, and diligent performance monitoring to avoid protracted legal disputes. Stop. Thank you.